elected, they may be appointed. They may be candidate for such position, or they may be the actual post holder. They include government officials, state officials, but also monarchs, kings, princes and queens. The UN Human Rights Committee insists that all public figures, including those exercising the highest political authority, such as heads of state and governments, are legitimately subject to criticism and political opposition. Okay, so what does that mean in practice? Because as we have highlighted earlier, the situation in many countries around the world tend to indicate that public officials do not like being criticized. So in theory, and indeed in the practice of a large number of countries, what it means is that public officials, elected officials, political leaders should tolerate greater scrutiny on their actions and greater criticism of their actions than a normal citizen. And in turn, if they don't accept it, the court should remind them that such enhanced scrutiny and criticisms are necessary to a democratic society and to public debate. The Inter-American Court of Human Rights, in the case of Herrera Ulloa versus Costa Rica, has established that it is logical and appropriate that statements concerning public officials and other individuals who exercise functions of a public nature should be accorded a certain latitude in the broad debate on matters of political interest that is essential for the functioning of a truly democratic system. In Africa, in 2015, the African Court for Human Rights ruled that Burkina Faso violated Article 9 of the African Convention, that's the right to freedom of expression. The court in particular stated that freedom of expression in a democratic society must be the subject of a lesser degree of interference in the context of public debate relating to public figures. Consequently, I'm still quoting the court, people who assume highly visible public role must necessarily face a higher degree of criticism than private citizens. Otherwise, public debate may be stifled altogether. So let's illustrate by some more examples how far this criticism may go. First of all, the level of protection afforded to criticism of political figures may translate into a different legal test and reasoning. One of the most important and older decisions concerning public officials and freedom of expression dates back to the struggle for civil rights in the United States. It's about an advertisement in the New York Times which accused the police commissioner of Montgomery, Alabama, of police brutality in its handling of civil rights protesters. A lower level court had attributed damages to the police commissioner, but the case went all the way to the US Supreme Court. And the court there recognized, as the previous one had done, that some of the statements in the advertisement were either false or at the very least misleading. However, it agreed to examine the defamation claim brought by the police commissioner against what it characterized, and I'm going to quote them here, as the profound national commitment to the principle that debate on public issue should be uninhibited, robust and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attack on government and public officials. On that basis, the US Supreme Court ruled that the public interest in protecting that form of speech greatly outweighed an occasional erroneous statement about a public official. That's a very important determination. Further, the court also held that the standard that must be applied by courts when publication makes statement about public or government official is not merely to determine whether or not the statement is false. Instead, the public official claiming defamation must prove that the publication set forth the statement with, and I quote, actual malice. putting there a new concept to you, maybe actual malice. What does this mean? It refers to a mental state at the time a statement is made. Was this statement made with the knowledge that it was false, or in reckless disregard as to whether it was true or false? It's a very important standard, one that has been the object of a number of court cases. And it basically means that when it comes to political expression concerning public officials, defamation claim must be assessed on a different basis than when the expression concerns somebody else. The actual malice standard applies in the United States to public figures and to public officials. As a higher test for defamation, it is meant to ensure that defamation cannot be used to silence public criticism. That reasoning has been influential in other countries beside the United States, in England, India, South Africa, the Philippines, and many others, where the actual malice test is often used with reference to criticism of public officials. International human rights courts have also stressed in their ruling that criticism of political and public officials may go as far as including offensive statements, that the action of public and government officials can be the object of close scrutiny, and that criticism of government should not be the object of prohibition. Let me highlight that from a case in the European Court, Lingens versus Australia. It's an older case, but still eminently relevant now. In October 1975, shortly after the Austrian general election, an Austrian journalist, Mr. Lingens, published 2 articles relating the activities of the 1st SS Infantry Brigade during the Second World War. The article also focused on Mr. Friedrich Peter, the president of the Austrian Liberal Party who had served in that SS brigade. And the article focused as well on his role in criminal proceedings instituted in France at the time at the end of the war. The journalist in those articles also criticized Bruno Kreisky, the retiring chancellor and president of the Austrian Socialist Party, accusing him of protecting the head of the Austrian Liberal Party and other members of the SS for political reasons. In his article, the journalist used such expressions as basest opportunism, immoral, and undignified. The retiring chancellor instituted private proceedings for defamation, and the Vienna Regional Court, holding that the retiring chancellor had been criticized in his private capacity, fined the applicant 20,000 shillings. On appeal, the fine to the journalist was reduced to 15,000 shillings. The case eventually reached the European Court for Human Rights in 1982. And the court ruled against Austria and in favor of the journalist. And it argued the following 4 things. First, freedom of political debate is at the very core of the concept of a democratic society. Second, the limits of accepting criticism are accordingly wider as regard a politician than as regard a private individual. Thirdly, Mr. Lingens' article dealt with political issues of public interest in Austria, which had given rise to many heated discussions concerning the attitude of Austrians in general to the participation of former Nazis in the governance of their country. Fourthly, the expression used in the article, including basest opportunism, immoral, and undignified, are to be seen against the background of a post-election political controversy. These expressions were in no way unusual in the hard-fought tussles of politics. So what the court there argued is that criticism of public officials can go as far as being expressed in offensive terms, and this ought to be okay under international human rights law. Indeed, courts have consistently emphasized that a politician inevitably and knowingly lays himself open to close scrutiny of his or her every word and deed by both journalists and the public at large, and he or she must consequently display a greater degree of tolerance. You find that commitment on the part of the court in many parts of the world. Members of parliament, local politicians, government, public authorities, or public figures in general have to accept even sharp criticism, sometimes expressed in a harsh or hostile tone. The European Court has also insisted that pluralism in a democratic society demands protection of not only statements that are favorable and inoffensive, but as well as those that offend, shock, or disturb, and that applies particularly to the political sphere. So in one case related to Turkey, the European Court found that even biased and offensive political speech that fell short of incitement to violence was within the realm of political speech, and thus its restrictions cannot meet the necessity requirement. The criticism may even concern a politician's private life. The European Court again has stated that political invective often spills over into the personal sphere. Such are the hazards of politics and the free debate of ideas, which are the guarantees of a democratic society. So basically what the European Court is arguing here is that the notion of private sphere, as far as